everybody. How are you? I hope you can hear me okay. Just let me know. Everything's going good since I did my little testing the last time. I'm doing something different right now. Um, I'm not doing the same thing that we tested, but hey, Chris. You guys can hear me okay? Just want to double check. I have animals crawling all over me, kind of trying to get it all done. But how's everything? How are you guys? Hey, how's it good? Oh, good. Sounds good. Looks good. Yay. Okay. Wonderful. I'm so happy. um, so how are you guys? So good to see you. So much has been happening, like we were chatting about a little bit last week, but okay. So we're going to dig into the Trump trials a little bit, sort of, kind of. There's more questions around the Trump trials today. That's what we're getting into. So we're rolling up our sleeves. We're getting ready. It's going to be an interesting talk. We're going to be looking at the two concepts of presidential immunity and double jeopardy and how those play into the Trump trials. And do they play into the Trump trials? But we'll see. So special counsel Jack Smith, who brought forward some of the trials that are going on. Specifically, right now, we're looking at the J6 trial, which takes place in oh my gosh, that was in DC. Of course, it's in DC, and the judge there is Tanya Chutkin, and so Trump has filed an appeals with the court. It goes directly to the judge who's actually presiding over the case. When you do an appeal initially, that's who your appeal goes to. It goes to the judge that is overseeing the case. So in this one, it is Tanya Chutkin for the dismissal, basically, of the case due to presidential immunity and or double jeopardy. And she has denied those. She has kept going forward with the case. And so he has sent that appeal now to the higher court in DC. And what's really interesting turn of events. Chris, can you text Cindy and let her know the show is going on right now? I don't know why this is still going off. Hold on. Let me mute my phone. Oh my gosh. I didn't or my watch. I did an update on it and now it's a little bit different. How do I mute it? Oh my gosh. Did anybody else do the update on their phone? No, that's not it. Oh my gosh. Why? Okay. We're just gonna hope that it's silent. You already sent that text. Okay, thank you. Okay, so Donald Trump sent his appeal to the next court up within DC, and in effectively that puts a stay on the entire case. So basically, what they're saying is that the courts in DC have ruled in the past that if there is a hey Cindy, if there is an appeal going on for something that would dismiss the case entirely, that the case itself should pause. It should stop until the appeal is resolved. Just to prevent confusion, prevent a waste of the court's time and money. Um, it automatically puts a stay onto the case itself. Well, so Donald Trump has done that, stating, "Hey, look, I've sent this appeal. You kind of have to pause the case now. Sorry if you don't like that, but you do." And of course, Jack Smith is arguing that they should continue on, even though we're trying to figure out this issue, whether or not the case should even happen. He's like, we need to continue on because they really don't want to move the trial date, which is March 4th, Super Tuesday. And because of the election coming up right now, they're not outright saying that, but there really wouldn't be any other reason to be pressing this court case to be moving as quickly as they have. It was brought forth in August, and now they want to start trial in March, which is incredibly fast, especially considering the ridiculous amount of discovery. I mean, it's something like 13 million pages, some of which Trump isn't and his lawyers aren't even allowed to read. The government's like, well, it's classified. Sorry, you can't read it. We're going to give you all the information that we think is relevant for you guys to have and that you can have. So he can't even read some of the evidence that's going to be used against him. So of course they're trying to fight that as well. But anyways, so they want to keep this case moving, right? And so special counsel Jack Smith, who was for the government, filed an appeal just recently to the Supreme Court of the United States. He's like, all right, I'm skipping over all of this. He's basically saying, look, you guys, you need to dismiss this. We need to figure out this is, what he's claiming. He has presidential immunity, double jeopardy. Like, we need you to rule on this now, and we need you to do it expeditiously because we got to get this going. We got to keep this thing on track. So, which is it's a little unusual, but not unheard of. But for them to just he's kind of skipping over the Court of Appeals in DC and going right to the Supreme Court. He's like, look, we're just going to do this. This is why. And then of course he cites cases as to why he's able to do this. Now, whether or not the Supreme Court agrees, that will be another thing. So we're going to go through his appeal to the Supreme Court, and then we're going to look at, well, what did the founding fathers say about this? Alexander Hamilton actually wrote about this a little bit. And so we're going to look at that. We're going to look at one of the Federalist Papers, and then we're going to also look at some kind of legal opinions about this. What are other people thinking? What does Congress think? What do legal scholars think? And we're going to take a look at these issues because I find them really interesting. So before we do that, just want to say a quick hi, everybody. Hi, Chris. Hi. Let's see, who all do we have? Mr. Catfish is here. Hey, how are you? Hello, Mindforked. XJ, let's do the damn thing. Yes, I know. It took me a moment, but we're here. We're here. Hey, Mark, how's it going? Hey, Cindy. I know I'm going through all you guys really quickly because I want to get to this. Hey, Renee. Don't look at the no UFO top secret declassified disclosure transparency. Look at it as if we now definitely know they're hiding. Interesting. Hey, Hellfire Studios is in the house. How are you? How's it going? Okay. Hero, hey, how are you? Hand pink waving. I love how StreamYard does the emojis. Hand pink waving. Okay, so let's look at the actual appeal that special counsel Jack Smith. Yay, you're alive. Yay. I don't know what that means, but I'll text you later to find out. Let's look at the appeal to the Supreme Court. We're just going to go right to the top. Like, we're not wasting time with these district courts. No. Jack Smith says we're taking it to the top. Okay, so hold on, let me just switch this around. There we go. All right, that's a little bit better, right? So pull that up. Okay, so Supreme Court of the United States versus Donald Trump on petition for a writ of certiorari before judgment. I should know how to say that. Certiorari. It's a hard one. It's like railroad. Before judgment to the United States Court of Appeals for the District of the Columbia Circuit. Okay, so special counsel Jack Smith, lots of other lawyers. Question presented: whether a former president is absolutely immune from federal prosecution for crimes committed while in office or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. So these are the questions, right? This is what we need to know. Is a president absolutely immune from federal prosecution for crimes committed while in office, and or is he protected under the double jeopardy from federal prosecution when he's already been impeached but not convicted? So those are the questions we're going to be looking at today. Good, juicy questions. Here we go. Here's information for you to read through. Okay, table of contents. Thank you so much. Quite a lot. Okay. Special counsel on behalf of the United States respectfully petitions for a writ of certiorari before judgment to the United States Court of Appeals for the District of Columbia Circuit. So just a little note there. He's saying before judge because normally you would wait until after judgment in order to file an appeal. But because of kind of the extraordinary circumstances that are going on with this case and Donald Trump running currently for president, they're basically saying this is why we're filing before judgment, because there's collateral damage that's going on right now, and we need to know whether or not we can even go forward with this case. So that's what Donald Trump originally stated when he filed his appeals in the first place, because like I said, you would normally wait until after the case is done in order to appeal it. but they're saying there's kind of special circumstances going on right here. The judgment of the district court, so that was Judge Chutkin, the judge that's presiding over the case that is against Donald Trump, was entered on December 1st, 2023. Respondent filed a notice of appeal December 7th. Court of Appeals jurisdiction rests. The jurisdiction of this court is invoked under such and such clause. Here are some cases. You can see all of these things. Wonderful. Constitutional provisions. Okay. This case presents a fundamental question at the heart of our democracy, whether a former president is absolutely immune from federal prosecution for crimes committed while in office, or is constitutionally protected from federal prosecution when he has been impeached but not convicted before the criminal proceedings begin. The district court rejected respondents' claims. So he's saying Judge Chutkin rejected Donald Trump's claims that these things make him immune, correctly recognizing that former presidents are not above the law. This is what they keep saying. No one is above the law. It's technically not really true. It's not 100% true. And we're going to get into that a little bit. And are accountable for their violations of federal criminal law while in office. Respondents' appeal of the ruling rejecting his immunity and related claims, however, suspends the trial of charges against him, scheduled to begin on March 4th. So this is why he's saying we got to get this going. It is of imperative public importance that respondents' claims of immunity be resolved by this court, and that respondents' trial proceed as promptly as possible if his claim of immunity is rejected. Respondents' claims are profoundly mistaken, as the district court held. So he's like, Judge Chutkin, she's very intelligent, she's very smart, she saw right through this. So we just need you to confirm that. But only this court can definitively resolve them. Okay, so let's see. So he kind of is going to be stating the facts. Respondent served as president of the United States from such and such dates. The indictment alleges that respondent engaged in systematic and deliberate efforts to overturn the results of the 2020 presidential election and prevent the lawful transfer of power to his successor. On August 21st, 2023, a federal grand jury, which is also questionable, by the way, we'll get into that in another episode maybe, sitting in the District of Columbia, charged respondent in a 4-count indictment. This is after he was already impeached for said situation and acquitted of such. Count 1, which charges a conspiracy to defraud the United States in violation of U.S. blah, 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 blah code, alleges that the respondent, then a candidate seeking re-election to the presidency, but also the president at the time, conspired with, among others, several individuals outside of the executive branch to overturn the legitimate results of the 2020 presidential election by using knowingly false claims of election fraud to obstruct the federal government function by which those results are collected, counted, and certified. This is interesting because we know that there have been cases that have been recently resolved where they have found that there was election fraud going on for said election. So you start to see some of the hypocrisy here. The indictment further alleges that respondent aimed at accomplishing the conspiracy's objective in 5 ways. And so they're going through, okay, so these are all of the claims against him, which we can go through at another time if we really want to dig into the case further. But let's get into what he's claiming here. Respondent moved to dismiss the indictment on the grounds inter alia, meaning in the middle of the proceeding, because of what is going on. So normally, as I said, the appeal would be done afterwards. That he enjoys absolute immunity from criminal prosecution for acts taken within the outer perimeter of his official responsibilities, and that the indictment's allegations all fall within that scope. He also argued that double jeopardy principles and the impeachment judge clause, U.S. Constitution, Article 1, Section 3, Clause 7, barred his prosecution. Double jeopardy and impeachment. The government responded that a former president has no such absolute immunity from federal criminal prosecution, that even if such immunity existed, it would be narrower than the outer perimeter standard that defines a president's immunity from civil liability. So this is interesting. So these are the things that Judge Chutkin said. And as we get into we're going to talk about Federalist Paper number 65 that was written by Alexander Hamilton. And you're going to see she's overstepping a little bit, in my opinion. She's overstepping a little bit in these judgments. That even if the standard applied, the indictment should not be dismissed because it alleges conduct falling outside of the outer perimeter of a president's official responsibilities. So the outer perimeter is kind of like Okay, so this is what we know that the president does. And then they're saying initially when they were kind of forming the Constitution and Bill of Rights and everything, really just forming the government. They were saying, okay, these are okay, standard. This is what we know the president does. But there's also kind of this outer perimeter of things that the president does that maybe aren't necessarily like his main responsibilities, but these are also things that he does. And one might argue that a president is a president 24/7 while he's president. So you could say that everything he does falls within the presidential realm, but there are some exceptions. So she's kind of saying, okay, I don't think like it's narrower than the outer perimeter, this presidential immunity, which sort of does go against kind of what has been said in the past. But she's saying even if it is inside, if it falls inside this kind of outer perimeter of presidential responsibilities, I don't buy it. I don't buy it. That's what Judge Chutkin has said. So the district court denied respondent's presidential immunity claim and his related double jeopardy claim. So basically, she's saying, yeah, you were acquitted. Okay, I don't care. The court concluded that the Constitution's text, structure, and history support the conclusion that the respondent may be subject to federal investigation, indictment, prosecution, conviction, and punishment for any criminal acts undertaken while in office. Although the Constitution's text does not address presidential immunity, the court observed that silence did not reflect an understanding that a former president possesses immunity from federal criminal prosecution for acts taken while in office. To the contrary, the court explained the one constitutional provision the respondent invoked, the impeachment judge clause, cut against his immunity argument. So this is the impeachment judge clause. Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So this is the impeachment judgment clause that is in the that is a part of the Constitution. And the issue that we're having here, there's really one word that is kind of causing controversy that people are arguing over. And it is where they said, but the party convicted shall nevertheless be liable and subject to indictment, trial, prosecution, et cetera, et cetera. He was never convicted. So Donald Trump's lawyers are, and not just him, but other people are saying, if you can only prosecute him if he's actually convicted. So the way that it works is that so the impeachment and impeachment trial is more of a political trial. It would remove someone from office, right? But it's not going to really it's not going to punish him. It's not going to create, it's not going to throw him in jail. They're going to simply remove him from office. It is a political trial. Once they're found guilty, they are still liable for criminal prosecution. But he wasn't found guilty. He was acquitted. So herein lies the question. Is it double jeopardy? Judge Chutkin says, nope, it's not. The court noted that the clause's first part limits the penalties of impeachment to removal and qualification from office, and the second part clarifies that the party convicted may face later criminal prosecution, that any further punishment may not come from the legislature. So I'm not really sure why they're I think they're just kind of overlooking the part about like once convicted. Maybe should just like, "No, I don't see that word. It doesn't mean anything." Let's see. Then they're also looking at the term nevertheless. So, which term? But the party convicted shall nevertheless be liable. So she's looking at nevertheless as opposed to convicted, stating that the term nevertheless clarified that the clause's first part addresses the penalties that the legislature could impose following impeachment, but does not bear on whether the party would also be subject to criminal prosecution. So she's saying that because that word nevertheless is in there, that means it's separate. Those are two separate things. Second, materials written contemporaneously with the Constitution, such as those from Alexander Hamilton, which we're going to read something from Alexander Hamilton, did not reflect the view, let alone a widespread consensus. Can't talk. As a respondent contended that the impeachment judgment clause rendered former presidents immune unless they were impeached and convicted. Also, not completely accurate. A lot of this you're going to see. This is all kind of new. This hasn't happened before. There's a reason why we don't prosecute presidents. There's a reason why. It opens up a huge can of worms, which we're now seeing. And it's it's just not a great idea. And it's the first time in our history that we're doing this. Um, but there's a reason why we haven't done it. Okay. Um, Respondents' interpretation would produce the untenable anomaly that a former president would be immune if he committed a crime that was not treason, bribery, or other high crimes and misdemeanors, for which impeachment is not available, committed a crime near the end of his presidency, or covered up the crime during the trial. This is a little bit ridiculous. And I've seen it on the news. And again, this is actually quite ridiculous in my mind. People like arguing, well, he could go in there and shoot someone and then just be like, well, I'm the president, I'm immune. No, it doesn't work that way. It doesn't work that way. Um, okay, let's see. So this is again, he's saying this is again why Judge Chutkin didn't agree with him. Um, In sum, the district court concluded that former presidents do not possess absolute federal criminal immunity for any acts committed while in office. The court similarly rejected respondents' claim that his acquittal in impeachment proceedings afforded protection under double jeopardy principles. Oh my lord. Why is everybody texting me now? Okay. Because I can't figure out how to get this to stop. Oh, don't you hate that when you get. Okay. I've muted my phone. Why is this still going to? When you get updates and it changes like basic things and now you can't figure it out. Okay, I'm just, you know what, I'm taking it off and I'm putting it somewhere else. Okay, hopefully that'll mute it a little bit. Sorry, guys. Okay, so basically, um, he doesn't have federal he doesn't have immunity, and we don't think that double jeopardy applies in this situation. Okay, and so Jack Smith says to the Supreme Court, a cornerstone of our constitutional order is that no person is above the law. Again, that is not technically correct. The force of that principle is that a zenith here, or zenith where, as here, a grand jury has accused a former president of committing federal crimes, a grand jury that is possibly unconstitutional, by the way. Keep that in mind. To subvert the peaceful transfer of power to his lawfully elected successor. Again, we're getting into other issues here where they're using words because they're lawyers. This is what they do, right? This is what they're trained to do, what they're paid to do. Um, he, as a president, in his presidential duties, is entitled to ensure that elections are not fraudulent. That is within the scope of the president's rights. But they're kind of like getting around that, saying, well, he subverted. They can't say he it was an insurrection because he hasn't. They didn't find him guilty of insurrection. Um, so mm, nothing could be more vital to our democracy than that of a president who abuses the electoral system to remain in office. He is allowed to question it. He's allowed to question it just like you're allowed to question it, and I'm allowed to question it, especially the president. The president should be ensuring that the election has been done as it should be and not fraudulently. Yet the respondent has asserted that the Constitution accords him absolute immunity from prosecution. So this is where it gets dangerous to me, because not only are they saying, well, he shouldn't be asking this. He should have just accepted the results, moved along. So that gets into the questions of what are kind of the office of the president. What is he entitled to do? And they're in another part of the trial, they're claiming, well, when he's running for president, that is outside of his presidential duties. But he is also president at the same time. He is. They're trying to say that, well, those are two very separate parts of like he's two different people at the same time. Yeah, I don't know. But also, we do have something called the First Amendment in this country. We do have free speech, or we're supposed to have free speech. Shouldn't he be able to say, I don't think this election is correct. I think that maybe there was an issue here with it, especially when we know that now that we have found in several cases that there have been and were issues with the election. Okay. Anyways, so basically he's saying we would like you to agree with us and just reject his constitutional arguments because we really want to get this going. March 4th. We got to go. Move along. Let's get it moving, people. Okay. So, yet, if this case proceeds through the ordinary and even a highly expedited appellate process, it is unclear whether this court would be able to hear and resolve the threshold immunity issues during its current term. So basically, he's like, we got to get it going. Okay. So you got to look at this immediately. I would like you to see this. We got this set for the 4th. We've already sent out things. We're trying to find a jury. We got stuff. We're already doing all of this. So he's going to go through all this. He's going to go through, okay, here's arguments. In conclusion, the petition for a writ of certiorari before judgment should be granted. Respectfully submitted, your friend, Jack Smith. So that is what Jack Smith has sent to the Supreme Court. And we will find out what they decide. And they may say there could be a couple ways that it could go. They could say, okay, we're going to take a look at this. And yes, we agree with you. Or no, we agree with Donald Trump. And on either of those. So either presidential immunity or double jeopardy. Even if just one, they say, yep, we agree with him. The case is dismissed. The charges are dismissed completely. The case will be done. And they could also say, whoa, wait a second here. You bumped up, like, let the appeals court handle this first. Then if there's an issue, we'll intercede when you appeal again at the right time. So they could also say that too. So we'll see. We'll see what they say. So what did the founding fathers say about this, right? So they brought up Alexander Hamilton. We're going to look at some of the things Alexander Hamilton wrote. Dorothy makes me suspect that both sides are zooming us. Well, of course, yeah, agreed, right? I mean, there are things on either, like they each have their motives, right? Of course, absolutely. Hey, Amy, how are you? So, Ben, the Yorkshire Euphonian is here. Hey, how are you? Okay. What do I think about Alex Jones on Twitter again? I think I haven't seen anything that he has said. I haven't really looked, to be honest. But I mean, I think everybody should be entitled to speak. I am a First Amendment absolutist, so good on him. I don't know what he said. I can't say to the one way or the other, but yeah. Okay, let's see. Let me find. Okay, here we go. I'm going to stop that and let me pull up our Federalist Papers so we can look at that and see. Where are we? Here we go. Okay. So the Federalist Papers were papers that were written around the time of creating the Constitution. So these are papers that talk about kind of the debate going on back and forth. So it gives us a, a window into the mind of why they wrote things the way they did. Some of them talk about things they discussed and whether those were accepted or not accepted, and ultimately became a part of the Constitution. So they're really, really fascinating. If you like history and you haven't read the Federalist Papers, definitely go take a look at them. But so this one we're going to look at Federalist Paper number 65. And this was written by Alexander Hamilton under the pen name. What was it? It's Publius. I don't know. It makes me very uncomfortable. Okay. So Federalist Paper number 65. That was his pen name that he used. I really don't know why. The powers of the Senate continued from the New York packet, Friday, March 7th, 1788, author Alexander Hamilton, to the people of the state of New York. The remaining powers, which the plan of the convention allots to the Senate in a distinct capacity, are comprised in their participation with the executive in the appointment to offices and in their judicial character as a court for the trial of impeachments. So he's talking about, in this paper, he's talking about impeachments and sort of the structure of how that should work. As in the business of appointments, the executive will be the principal agent. The provisions relating to it will most probably be discussed in the examination of that department. We will therefore conclude this head with a view of the judicial character of the Senate. So he's saying, okay, there's other things that are relevant to this, but as for this discussion right now, we're looking at the judicial character of the Senate in regards to impeachments. A well constituted court for the trial of impeachments is an object not more to be desired than difficult to be obtained in a government wholly elective. The subjects of its jurisdiction are those offenses which proceeded from the misconduct of public men, or in other words, from the abuse or violation of some public trust. So this he's kind of getting into like why do we need an impeachment court? They are of a nature which may, with peculiar propriety, be denominated political, as they relate chiefly to injuries done immediately to the society itself. So he's saying it's not really a civil court case, it's not a criminal court case. These are injuries that are done to society, to the general public. The prosecution of them, for this reason, will seldom fail to agitate the passions of the whole community and to divide it into parties more or less friendly or inimical to the accused. In many cases, it will connect itself with pre existing factions and will enlist all of their animosities, partialities, influence, and interest on one side or the other. And in such cases, there will always be the greatest danger that the decision will be regulated more by the comparative strength of parties than by real demonstrations of innocence or guilt. So, what is he saying here? He's saying these are difficult trials. These are going to divide people. They are going to bring out kind of everyone's passions about what it is they believe with regards to whatever this misconduct was, right? So it's going to bring out kind of the ugliness, is what he's saying. So that's why these are difficult and why it's so important that we have the right group of people acting as the impeachment court. So they're still trying to figure out who's going to do this in this discussion here. The delicacy and magnitude of a trust which so deeply concerns the political reputation and existence of every man engaged in the administration of public affairs speak for themselves. The difficulty of placing it rightly in a government resting entirely on the basis of periodical elections will as readily be perceived when it is considering that the most conspicuous characters in it will, from that circumstance, be too often the leaders or the tools of the most cunning or the most numerous faction, and on this account can hardly be expected to possess the requisite neutrality towards those whose conduct may be the subject of scrutiny. So he's saying there's going to be political biases. The convention, it appears, thought the Senate that the most fit depository of this important trust. Those who can best discern the intrinsic difficulty of the thing will be least hasty in condemning that opinion, and will be most inclined to allow due weight to the arguments which may be supposed to have it produced it. So he's saying, yeah, I think the Senate is probably good. They're going to be knowledgeable. They're going to be they're not going to be hasty in condemning different opinions because they're involved with this to a certain extent, and so I think they might be good. Is kind of where he's at this point. What, it may be asked, is the true spirit of the institution itself. So what should this impeachment court be? It is not designed as a method of national inquest, sort of is now, into the conduct of public men. If this be the design of it, who can so properly be the inquisitors for the nation as the representatives of the nation themselves? So he's saying, if this is what we're going to be doing, right? If this is a national inquest, like if that's what becomes of this, like who better than the people that have been elected to represent the nation itself? It is not disputed that the power of originating the inquiry, or in other words, of preferring the impeachment, ought to be lodged in the hands of one branch of the legislative body. Will not the reasons which indicate the propriety of this arrangement strongly plead for an admission of the other branch of that body to share in the iniquity? So basically, he's saying, I think the House and the Senate should both weigh in on this. The model from which the idea of this institution has been borrowed pointed out that course to the convention. In Great Britain, it is the province of the House of Commons. Great Britain does this too. Several of the state constitutions do this. So is this not the true light in which it ought to be regarded? Where else than in the Senate could it have been found a tribunal sufficiently dignified or sufficiently independent? What other body would be likely to feel confidence enough in its own situation to preserve unawed or uninfluenced the necessary impartiality between an individual accused and the representatives of the people, his accusers? So they're saying, who better, or he's saying, who better than the Senate to have confidence enough to be unpersuaded to sort of hopefully, in an unbiased way, look at the individual accused in a more impartial way and represent the people. That is what they're supposed to do. Could the Supreme Court have been relied upon as answering this description? It is much to be doubted whether the members of that tribunal would at all times be endowed with so eminent a portion of fortitude as would be called for in the execution of so difficult a task. So he's saying, I don't think this Supreme Court can do this. I don't think that they are the right group of people to be doing this. And it's still more to be doubted whether they would possess the degree of credit and authority which might, on certain occasions, be indispensable towards reconciling the people to a decision that should happen to clash with an accusation brought by their immediate representatives. So he's saying, if there's upheaval, I don't think the Supreme Court is going to be able to do anything to stop people from getting angry about this. They're going to make a decision and move along. A deficiency in the first would be fatal to the accused. In the last, dangerous to the public tranquility. So he's like, we want to make sure that it's fair to both the person being accused and to the public. We want someone who can handle both sides of the coin here. The hazard in both these respects could only be avoided, if at all, by rendering that tribunal more numerous than would consist with a reasonable attention to economy. The necessity of a numerous court for the trial of impeachments is equally dictated by the nature of the proceeding. So he's saying we need a big group. We need a large group of people, not just the Supreme Court justices. There's not enough of them. We need a large group of people to weigh in on this to make it more fair. This can never be tied down by such strict rules, either in the delineation of the offense by the prosecutors or the construction of it by the judges, as in common cases serve to limit the discretion of courts in favor of personal security. There would be no jury to stand between the judges who are to pronounce the sentence of the law. If the Supreme Court, there's no jury in the Supreme Court. So there wouldn't be a jury. There's not a jury of peers. Okay, so basically, forbids the commitment of the trust to a small number of persons. So again, the Supreme Court, it's not large enough. These considerations seem alone sufficient to authorize a conclusion that the Supreme Court would have been an improper substitute for the Senate as a court of impeachments. There remains a further consideration which will not a little strengthen this conclusion. It is this: the punishment which may be the consequence of conviction upon impeachment is not to terminate the chastisement of the offender. After having been sentenced to a perpetual ostracism from the esteem and confidence and honors and emoluments of this country, he will still be liable to prosecution and punishment in the ordinary course of law. Would it be proper that the persons who had disposed his fame and his most valuable rights as a citizen in one trial should, in another trial for the same offense, be also the disposers of his life and fortune? So he's saying, they're still liable for criminal prosecution if they are convicted in an impeachment. So the impeachment takes them out of office, right? It takes them out of public office. So the people who are deciding whether or not to convict in an impeachment make that decision. And so he's saying, is it then fair to have those same people try him again in a criminal court and then further place sanctions against him? And so he's saying it's not fair to the person being accused to have the same group of people making both of those decisions. Because there could be a strong bias. One decision would be apt to overrule the influence of any new lights which may be brought to vary the complexion of another decision. Those who know anything of human nature will not hesitate to answer those questions in the affirmative, and will be at no loss to perceive that by making the same persons judges in both cases, those who might happen to be the objects of prosecutions would, in a great measure, be deprived of the double security intended to them by a double trial. So he's saying we purposefully want two different groups of people presiding over two different cases. We don't want the same group presiding over both of these cases for the same person. Okay. Blah, blah, blah. Would it have been an improvement of the plan to have the united of the Supreme Court with the Senate? So maybe is it better to have the Supreme Court and the Senate joined together for an impeachment court? This union would certainly have been attended with several advantages, but would they not have been overbalanced by the single disadvantage already stated arising from the agency of the same judges in a double prosecution? So he's like, the same situation would still apply. The Supreme Court would then be judging on the impeachment and in a criminal trial. So that's not going to work. Would it have been desirable to have composed the court for the trial of impeachments of persons wholly distinct from other departments of the government? So, should it be people who aren't even in the government? Should they be the ones that preside over the court of impeachment? There are weighty arguments as well against as in favor of such a plan. To some minds, it will not appear a trivial objection that it could tend to increase the complexity of the political machine to add a new spring to the government, the utility of which would be at best be questionable. So he's saying, like, I think that's making it overly complicated. I don't think we need to do that. But an objection, which will not be thought of by any unworthy attention, is this: a court formed upon such a plan would either be attended with heavy expense or might in practice be subject to a variety of casualties and inconveniences. It must either consist of permanent officers, stationary at the seat of government, and of course entitled to a fixed and regular stipend, or of certain officers of the state government to be called upon whenever impeachment was actually depending. So he's saying it either needs to be a fixed institution, so a fixed group of people, whether voted in, I don't know if he says that, or elected or assigned, or already people who are working within the government that maybe are in different departments that, like, hey, you're going to be a part of the impeachment court, you're going to be a part of it, you're going to be, and then when it's necessary, we'll bring you all together. um it will not be easy to imagine any third mode materially different which could rationally be proposed, as the court, for already reasons given, ought to be numerous. So he's saying we already want it to be a large group of people. It needs to be a large group of people. So this is going to make it very complicated. Let's see. The advantage to the guilty from the opportunities which would delay would afford to intrigue and corruption. Okay, so he's saying, so if we need to kind of create this impeachment court at the time of an impeachment, it's going to cause a long delay, which, people are going to talk. So as you said, it would afford intrigue and corruption, or could. And in some cases, detriment to the state from the prolonged inaction of men whose firm and faithful execution of their duty might have exposed them to the persecution of an intemperate or designing majority of the House in the House of Representatives. Though the latter supposition may seem harsh and might not be likely often to be verified, yet it ought not to be forgotten that the demon of faction will, at certain seasons, extend his scepter over all numerous bodies of men. But though one or the other of these substitutes which have been examined, or some other might be devised, should be thought preferable to the plan in this respect reported to the convention, it will not follow that the Constitution ought for this reason be rejected. If mankind were to resolve to agree in no institution of government until every part of it had been adjusted to the most exact standard of perfection, society would soon become a general scene of anarchy, and the world a desert. Who will undertake to unite the discord of opinions of a whole community in the same judgment of it, and to prevail upon one conceited projector to renounce his infallible criterion for the fallible criterion of his more conceited neighbor? To answer the purpose of the adversaries of the Constitution, they ought to prove not merely that particular provisions in it are not the best which might have been imagined, but the plan upon the whole is bad and pernicious. So he's basically saying, we like the setup of the Senate and the House doing it, and we think this is going to work out the best. So why is this important? Why is this, like, who should be the impeachment court? Why is this important? Well, it's important because he is talking about first having the impeachment. If they are convicted in the impeachment, then criminal proceedings can go on. They will be liable for criminal proceedings as well. So in this case, Alexander Hamilton is saying this is first. The impeachment is first, and then criminal proceedings. Once they're convicted, criminal proceedings can then proceed afterwards. So he is making it very clear that he thinks there is one and then the other, right? If you're convicted, then criminal proceedings can go on. Is there going to be a quiz? There is. So study and take copious notes. So this is why these questions are really fascinating to me, because there is room for discussion. There is room for interpretation. There isn't anything specifically stated in the Constitution about presidential immunity, which we're going to get into as well. But there's nothing specifically about impeachment and double jeopardy either. So there is room for interpretation here. But based upon what we're reading from Alexander Hamilton, it seems though as though he's saying impeachment is first. If that's convicted, then you can move on to federal crimes. Now, the government is currently arguing, well, he doesn't say that if you're not convicted, you can't be also prosecuted for federal crimes. And they're saying just because he didn't say that doesn't mean that he thinks that that's bad or that he thinks that that's not accurate. So are we going to then make the supposition that we understand what he was saying by leaving that out? I don't know. I don't know. What do you guys think? Hey Cassie. Okay, so uh Dave on animal. Luckily, they're sleeping at the moment, so fingers crossed they stay that way. So, what does Congress think about this? I mean, they have looked at this, right? There have other presidents have there is an interesting history of other presidents being uh indicted for different reasons. Not a lot, nothing to the extent that we're dealing with right now. But what does Congress have to say about this? Let me where did I have okay, here we go. So let's see what they say. And like I said before, if you guys have any questions, I don't know if I said it this time, but I think you guys know. If you have any questions, put them in all caps. And when we kind of get through all of this, we can go through any questions and any like super chats and all of that, which are wonderful. I will also make sure that I give you a shout out after we go through all of these, just so we can sort of streamline and get through these all. All right, so let's pull up the presidential immunity based on what the Constitution says. So this is from congress.gov, Constitution annotated. So this is, oh, sorry. I think I accidentally hit my microphone. Article 2, Section 3, presidential immunity. Oh, hold on a second. Oh, that was the beginning of it. Okay. This is an interesting section, an article, and this is where presidential immunity comes from, though it's not explicitly stated. He shall from time to time give to the Congress information of the state of the Union, and he may recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, and either of them, and in case of disagreement between them with respect to the time of adjournment, he may adjourn them to such time as he think proper. And he shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. So they're looking at this saying, okay, this is where we believe that the president is sort of above the law to a certain extent. And so we have a little bit of a discussion about it. In 1867, decision of Mississippi versus Johnson, the Supreme Court established that the president is largely beyond the reach of the judiciary by holding that it could not direct President Andrew Johnson in how he exercised his purely executive and political powers. The court stated it had no jurisdiction to enjoin the president in the performance of his official duties. So this is kind of where it started, right? And so when I say they keep saying no one is above the law, that's not entirely correct. In fact, the Supreme Court has already ruled that to a certain extent the president is above the law. He is the person who exercises these political powers and executive powers. And so to a certain extent he needs to be above the law. Now again, this is not saying like he can just go and shoot everyone in the office and it's going to be all, hunky dory. They're not saying that. But what they're saying is in the course of doing his duties, to a certain extent he is above the law. In subsequent decisions, however, the court made clear that Johnson does not stand for the proposition that the president is immune from judicial processes. Okay, so he is above the law to a certain extent, but he is still subject to some judicial processes. For example, the United States versus Nixon, the court held that President Richard Nixon was amenable to a subpoena to produce evidence for use in a federal criminal case. So this is not saying that while he was president, they could prosecute him or anything. Basically, it's just saying that he had to respond to the subpoena to produce evidence. So in that sense, he wasn't immune to it. He did try to argue that he was immune to the judicial process, claiming that the independence of the executive branch within its own sphere insulates a president from a judicial subpoena in an ongoing criminal prosecution. The Supreme Court unanimously disagreed with that, holding that neither the doctrine of separation of powers nor the need for confidentiality of high level communications without more can sustain an absolute unqualified presidential privilege of immunity from judicial processes under all circumstances. So they're saying, no, 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 no. No, sorry, my man, you're not immune from all judicial processes. If we subpoena you for some information, you still got to give it to us. The court noted that the constitutional duty of courts to do justice in criminal proceedings was counterbalanced by the claim of presidential immunity. So we got to have both, right? We need to have that balance. That's why we have the different branches of the government. To accept the president's argument, the court further reasoned would undermine the separation of powers that was at the core of a workable government. So throughout the Watergate investigation, it was unclear whether the president could be subject to a criminal prosecution prior to being convicted upon impeachment. So this question, it's not the first time this question has come up, right? The court, however, resolved that the courts may require the president to testify or produce documents in criminal proceedings. So they didn't really, I guess, come to a conclusion about whether or not he could be prosecuted prior to being convicted upon impeachment, and he was pardoned. Ultimately, he was pardoned, but um, so they never really had to, I guess, answer the question to the extent that we need it answered today. This principle dates to the earliest days of the Republic when Chief John Justice Marshall presided as the Circuit Justice for Virginia over the treason trial of Aaron Burr. In that case, Chief Justice Marshall concluded that President Thomas Jefferson could be subject to a subpoena to provide a document relevant to the trial. So again, they're saying, yeah, you still got to provide these documents if we're asking you for them. Chief Justice Marshall declared that in contrast to common law privileges afforded to the King of England, the president was not exempt from the general provisions of the Constitution, like the Sixth Amendment, which provides the defense compulsory process. So again, this is more just about providing evidence. If they're asked for documents, they need to provide the documents. Nonetheless, Chief Justice Marshall recognized that while the president could be subject to a criminal subpoena, the president could still withhold information from disclosure based on executive privilege. So even though they need to respond to the subpoena in certain circumstances, they can still withhold information. In 2 centuries since the Burr trial, the executive branch practices and Supreme Court rulings unequivocally and emphatically endorse Judge Justice Marshall's position that the president was subject to federal criminal processes. In its 2020 opinion in Trump versus Vance, the court extended this precedent to state criminal proceedings, concluding that the president was not absolutely immune from state criminal subpoenas. So again, still talking about subpoenas here. Finally, with respect to civil liability, the court held in Nixon versus Fitzgerald that the president is absolutely immune in actions for civil damages for all acts within the outer perimeter of his official duties, which is interesting because there are some civil cases going on right now. Now, the ones brought by the government aren't for acts that were done while Trump was president. They're trying to get him on things within his business, which also very questionable in my opinion. But there are some cases, and I do believe there was a DC ruling that he could be liable in civil, or he could be tried in civil cases. I have to look at that again to see in what way he could be tried, but I believe it was with regards to January 6th that he could be um, tried civilly for those cases, which seems to go against this particular ruling. So that's interesting. We'll have to look at that a little more closely. So the court's decision was premised on the president's unique position in the constitutional scheme. That is, the court conducted a kind of public policy analysis of the policies and principles that may be considered implicit in the nature of a president's office in a system structured to achieve government under a constitutionally mandated separation of powers. So basically what they're saying is that, look, the president needs to be able to make these decisions, and he can't constantly be worried about being sued afterwards for these decisions that he sometimes has to make very quickly and in the best interest of the nation. And so that is one of the reasons why we have not prosecuted former presidents, because we don't want presidents being worried about being sued later on. Um, Okay. Although the Constitution expressly afforded members of Congress immunity in matters arising from speech or debate and was silent on presidential immunity, the court nonetheless considered immunity to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers supported by our history. So again, they're saying even Congress is agreeing. Look, they need to be able to do these things without being worried about being sued. Um, let's see. The president is charged with a long list of supervisory and policy responsibilities of utmost discretion and sensitivity, and diversion of his energies by concerns with private lawsuits would raise unique risks to the effective functioning of government. Moreover, the presidential privilege is rooted in the separation of powers doctrine, counseling courts to tread carefully before intruding. So, again, this is kind of like careful. You might be opening up a can of worms here, and which is what we're seeing. They are opening up a can of worms, indeed. While some interests are important enough to require judicial action, the court reasoned that merely private suits for damages based on presidential acts do not serve this broad public interest, necessitating the courts to ask. Finally, qualified immunity would not adequately protect the president because judicial inquiry into a functional analysis of his actions would bring with it the evil immunity it was to prevent. Absolute immunity was required. So they found absolute immunity is, in fact, required for presidents. Okay. Um, is this anything we need to worry about? Different rules prevail when an official is sued for a constitutional tort for wrongs allegedly in violation of our basic charter. Although the court was hinted that in some sensitive areas, officials acting in the outer perimeter of their duties may be accorded an absolute immunity from liability. I don't know that that's necessarily talking specifically about president. It looks like they were talking, just reading it quickly, that it might be other supportive a subordinate executive officer may be held liable, but looks like they're saying that someone under him that might be doing it could be held liable, but that basically the president still needs absolute immunity uh, from liability. So Congress has found that the president should be afforded absolute immunity, and it's necessary in order for him to be effective in his office. Um, what's Cindy saying? I think that had to do with liability for those injured protecting the Capitol on January 6th. I'm not sure what had to do with the liability for that. Um, so, okay. What inspired the stream? Total surprise to me. Well, here you go. Mr. Hurley answered it. Lynn and I are both tired of government and all their crap. This is the kind of stuff that gets talked about in our household all the time. Okay, so basically, Congress agrees the president should have absolute immunity. The Supreme Court in the past has agreed that the president should have absolute immunity. Now, again, this isn't saying that they aren't subject to any laws. They're just saying that within his capacity as president, and in my opinion, stating that you believe an election was fraudulent, again, especially since we now know that was true in some, I think in two cases it's already been determined that that was actually the case. um that is well within the scope of the presidential duties, right? Okay, so and ultimately let's look at a legal opinion on this, and then we'll get into more of a discussion. If you guys have any questions, again, make sure you put them in caps. That way I can find them. later when we're all done. Let's look a little bit at the double jeopardy as well. So this is a legal opinion. Hold on, let me pull this one up. So this gentleman, sure, I have this up here. Okay, there we go. Is Ronald W. Chapman. He's a legal analyst, Supreme Court expert, an author, and a speaker. And he wrote this article, Does Double Jeopardy Apply to Impeachment Proceedings? And he talks about another article, The American Mind, that suggests Donald Trump can't be convicted in Jack Smith's January 6th indictment because he was impeached and acquitted. So the things that we have been talking about, the argument is that Article 2, Section 1 of the Constitution reads, "The executive power shall be vested in a president of the United States of America. From that power flow certain privileges and executive immunities, which are expressly delineated in the Constitution itself." So proponents of this argument contend that the Constitution lays out the specific processes by which the President of the United States are to be prosecuted, though through impeachment rather than traditional prosecution due to the uniqueness of the office itself. So this goes back to what we were discussing in the Federalist Papers that Alexander Hamilton wrote about, where because the president is such a it's a unique office, right? And there are unique circumstances. And so this is why we wanted a court for impeachment specifically versus just having them prosecuted in a typical court. There are other considerations here. Notably, the impeachment judgment clause of the Constitution, Article 1, Section 3, reads as follows: A person convicted upon impeachment shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Some argue that this allows an indictment only after a person is convicted and convicted only. So he's saying, is that argument legitimate? So he's going to break it down. He says DC Citric DC Circuit Court rejects his theory. In the case to look at is Hastings versus the United States from 1989. In Hastings, a federal judge made much the same claim. He suggests that the they cannot be convicted of an offense by a criminal indictment where he was first impeached. The DC Circuit made quick work of this claim by dismissing it outright. The circuit points out that impeachment trials are distinguished in the Constitution from criminal trials. The accused has no right to a jury, and the president may not pardon a person convicted by impeachment. So that is true. That the only thing a president cannot pardon is a conviction by impeachment. They note that the framers understood that impeachment trials were fundamentally political, which seems to indicate that partiality is not guaranteed. Moreover, the federal rules of evidence don't apply to impeachment trials. Of course, Hastings dealt with a federal judge and not the privileges and immunities of the office of the president. However, it appears that Trump is not on solid footing with the DC Circuit. So that's the circuit that Judge Chutkin, who's overseeing his case, is within. However, but the argument is not entirely meritless that he should be immune from the prosecution because the acts were committed while he was still in office. It seems that the framers intended for impeachment trials to be the way in which was to pursue a president for high crimes and misdemeanors, not federal indictments. The express wording of the Constitution provides a significant hurdle to Jack Smith, the special counsel for the government, in dismissing the double jeopardy claim. A person convicted upon impeachment shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Did the framers intend that someone acquitted cannot be charged? Is a conviction after impeachment the prerequisite for criminal charges? One would think that if that was the intent, the framers would have expressly said so. Despite negative case law in the DC Circuit, there's a fair amount to support this idea of pre-Trump legal opinion memos. In one Office of Legal Counsel memo from 2000, the author asserts that impeachment exhausts every single legal remedy for redressability, and therefore bringing subsequent charges runs in violation of the double jeopardy clause. Given the obvious lack of case law on the issue, this will be a matter of first impression for the Supreme Court. While the argument has merit, the concern is that this would prevent prosecution of other federal officials subject to removal by impeachment and would require impeachment before criminal charges. This would insulate the government too much from indictment and may leave the potential for more corruption. So basically he's saying, okay, there might be some validity to this, but does that give the government too much wiggle room. And by the government, we specifically mean the president, because the president is the one who we're really talking about here, like the office of the president. So I don't think this extends to any other government officials as well. So he's saying, well, I can see both sides of the coin. So maybe, but he does seem to think that, like, yeah, this is a hurdle like Jack Smith is going to have to figure out how to overcome. And so he sent it to the Supreme Court. We're going to see what the Supreme Court has to say about it. And it'll be interesting. It'll be an interesting, this is kind of like a first for the Supreme Court to really have to like look at this and make this decision. And so it'll be really interesting to see what they do with it. I don't know. What do you guys think? What do you think is going to happen? Any thoughts one way or the other? Do you think the Supreme Court is going to say, yeah, we agree with Donald Trump on either presidential immunity or double jeopardy, or we think they're gonna agree with him on both, or do we think they're gonna say nope, no, 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 no. Remember, they only have to say yes to one of those in order for the charges to be dismissed. Or do you think they're going to say, hey, you know what? You need to go through the proper channels first. Um, yeah, we understand that you think that there's a rush here, Jack Smith, but you still need to see what the appeals court says. Then we'll see if we can if we need to just like intervene. If you don't like what they have to say, then come back to us. So I don't know. I kind of am leaning in that direction, but it is an interesting case, right? It is an interesting case to see what are they going to say. I don't know. I really don't know at this point. But what do you guys think? What is anybody else saying? Let me see. Okay, so those are the heavy duty documents. I don't know. So let's see. What's Dorothy saying? I think Trump's case is sort of like OJ's case. To find him guilty would have released yeah. Yeah, it'll be interesting. I think it's going to be either way. Either way. And this is why, again, you don't prosecute presidents, because either way they rule, some faction of the population is going to be pissed off, right? They have riled the public up so much about this. And you can see this, like there is a psyop going on against Trump, like you would not believe. And I'm preparing a bunch of evidence to show you guys that. And they are riling people up. They are using specific words. They are painting him in a certain light. They are purposefully doing this. And I say that because there are so many people using the exact same words and describing him the exact same way that it's not coincidental that they're all saying this, right? So they're riling people up. They are gaslighting America right now. And one way or the other, whatever way this ends up going, there's going to be a group of people that is extremely pissed off. Extremely pissed off. There's just no way around that. Words are powerful, David Hurley. Yes. It's true. They are. They are one of our most powerful weapons. And they're using it. And they, unfortunately, it is, I mean, I don't know. I look at it and I think, how are people buying this? And it's not because I don't think that, like someone who believes them is stupid. Like I'm not saying that, but what I'm saying is to me, it's obvious what they're doing, right? It's so like you see these things and it's so repetitive that it's like, how are you not getting that this is totally coordinated here? It's really crazy. It's really crazy. So we're going to talk about that. Hopefully this week I'm going to get that done as well. Maybe on Friday we're going to get into all of the psyops. Well, we'll see. We'll see. Maybe the Supreme Court will come back with a ruling before then too. So that'll be interesting. We can get into that and see what they have to say. Hatch said, hey, Ash, by the way, the swamp needs to be emptied. It does. It's crazy. It is. Like, if there weren't so many civil infractions, like civil liberties infractions right now, like, it would be just, it's insane what's going on. It really, it truly is insane. There's no other way to describe it. It's crazy. It's absolutely crazy. So, yes, it does. It does. But then, what do you do? Who do you bring in? Like, it's complicated, right? It's just a complicated situation. So, I don't know. I don't know. I don't know that it is anything that can be done quickly and or easily. I think it's something that we're going to have to really just like go through the muck and figure it out and hopefully on the other side come out in a better place. I don't know. But we're starting here, right? This is our starting point. So it'll be interesting to see what the Supreme Court does with this. I don't know. What do you guys think? Lulu has an opinion on it as well. So that's kind of like that's where we're at right now. We're just waiting on the Supreme Court to see if they're even going to take it. We don't even know yet if they're even going to take it, and make a ruling on it. So we're still kind of even just waiting to hear that. As far as I know, let me just double check and see if there's anything that has come up today about it. Let me see. Um, let me just do. Um, I don't see anything. Let's see. A Supreme Court weighs in. Does it say? Mm, okay. Yeah. Okay, so this doesn't say. Late Monday, the top court agreed to speed up. Wait, normally a respondent gets a month to file a brief opposing an appeal. Late Monday, the top court agreed to speed up that part of the process. In Trump's case, the Supreme Court ordered the former president to respond to Smith's appeal by December 20th, a little over a week. Once all the briefings are in, the Supreme Court will decide whether or not to grant the case, which would kick off a new round of briefing and oral arguments. Okay, so Donald Trump has until the 20th to respond. And then after that, they will make their decision as to whether or not they were going to take it on. So it'd be interesting. I'm curious as to how he's going to respond because those are the questions he's been asking too. So he might be like, "Yeah, what do you think about this?" And he's going to give them arguments as to why he thinks they should rule in favor of yes, these things do apply. Dorothy says, when you see these patterns repeating over time, that's when the matrixy nature of our existence becomes obvious. It does, or it's just humanity, right? The nature of humanity. Like we're just a quarreling, quibbling little group, aren't we? Sometimes. But it's interesting. It's an interesting case. So anyway, I just wanted to go over that with you guys. Like I said, I'm going to try and get together a show about the Trump psyop that's going on right now. Hopefully, if I can get that all together, I'm trying to get a bunch of clips for you so you guys can actually see it. Hopefully, I'm going to get that all together and ready by Friday. And get that done for you. If not, we will get that done next week. But that's going to be an interesting one. But I'll keep an ear out for anything that happens too with the Supreme Court. If we hear anything, I mean, I'm assuming Trump is probably going to respond before the 20th. So hopefully, we'll see how long. They've got a bunch of other trials that they're dealing with, so we'll see. But this is the big question, right? So this would put kind of a what's the word I'm looking for? It would make a lot of the other trials difficult. So yeah, again, I think I had said this the last time, but if anybody wants to help with research, the more I can get help with research, the faster I can get some of these episodes out to you. So if there's anybody who's sitting around and wants to help me with some research, just send me a message. I would love any help that I can get. And yeah, So that's it. Thank you guys so much for joining me. Thanks for sticking through all of the. I know some of the documents are a little bit dry sometimes to read, but I think they're important. Our history is the foundation of who we are at this, and so it's important to know, right? Because I think at this point we've become so disconnected from it, um, that sometimes we forget maybe what the founding, or we assume that we knew what was in the minds of the founding fathers. And I think it's really interesting to go back and actually look and see what they said. So thank you guys so much for joining me. And like I said, I will try to get that. I just want to double check that I'm not missing any questions. I'm going to try and get that other show on Friday. If I can't, it will definitely be next week. And I will talk to you guys soon. Thank you so much for joining me. And let me pull up a song for you to go out on. And I hope you have a wonderful day. All right, I'll talk to you later.
Lay you down on the softly spoken words and notions that delight, but you're right down the path I know too well. You're right, but in my head there's a picture of me finding who I am and who I should be. I've lost myself in the insanity. I know now I'm finally free. Slow me down, though the past is broken. Hope has opened a new bright, but you're right down the path I know too well. You're right, but in my head there's a picture of me finding who I am and who I should be. I've lost myself in the insanity. I know on a limb now I'm finally free. But in my head there's a picture of me finding who I am and who I should be. I've lost myself in the insanity. I know now I'm finally free. I'm out on a limb, and in my head I'm out on a limb, and in my head I'm out on a limb, and in my head I'm out on a limb. I've lost myself